Hello, family. My name is Des, and today we are still looking at the English legal system and we're zeroing in on the topic law and justice. Let's get right in. Alright, fam, welcome back. So, we're going to start off by defining things. We always like to define things, but the problem with so many legal terms is that we don't have specific definitions for things. So, we sometimes use synonyms, sometimes use a number of ways to try to explain concepts in law, and justice is one such concept. So justice as a concept that can be described simply as a synonym such as fairness, equality, and even-handedness. So there's a wide range of theories available to explain its meaning and how it is applied. So there are three types of justice that we're going to be looking at. Number one, we're going to be looking at what is called procedural justice. And then we're going to be looking at what is called corrective justice. And then lastly, we're going to be looking at what is called substantive justice. Now, let's look at procedural justice. So when we're looking at procedural justice, I need you to understand this real quick, that if, for example, in criminal law, right, if you don't know what is the difference between criminal law and civil law, please just go and watch the video on that. It is under this playlist. You can just get that, watch that, and understand the difference. But for example, in criminal law, when we're looking at procedural justice, we're saying it is true that the law can say everyone who steals is supposed to be put in prison, right? But that's justice in the sense of what the law actually says, right? But if I catch someone who's trying to steal, I don't just throw them in prison, right? There are some processes that needs to be followed so that there is procedural justice, so that people are not just taken to prison without them being heard in a fair and open court. Right? Because imagine if the police could just take people and throw them in prison without the courts and everything. It means that there are so many people who are going to be innocent, who are just going to be thrown in prison, who have not done anything wrong, but the police maybe suspect that they did it. So there will be no procedural justice. So when we're looking at procedural justice, we're looking at how do we make sure that justice is served. If a person is suspected of stealing, how do we try them? How do we determine if they're guilty or not, if they're supposed to be put in prison or not? That process, it is supposed to be fair, it is supposed to be just, and that's what we're calling procedural justice. So it is about making and implementing decisions according to fair processes. It is following a fair process of arriving at a decision and implementing it. So everyone has a right to access justice, to receive a fair hearing, and to understand their legal rights and obligation. But there's a flip side to it. However, many people need help to access and use these rights. So, for example, a person who cannot afford legal representation can be said to have no right to a fair trial. The process will not be fair as they will not have representation. So procedural justice can be considered from the aspect of availability of legal aid. And legal aid, it is when the government assigns lawyers to help people who cannot afford to hire lawyers on themselves. So if someone who is less privileged, who does not have enough money, cannot hire a lawyer, which means the process by which their case is going to be heard, the process by which the courts are going to decide whether the person is guilty or not, is not going to be fair. Because this person is not going to be having representation. He's not going to know what to do. He is going to be fighting against a state lawyer or another lawyer who knows the law, who knows everything, and this person is not going to be knowing anything. And so that will put them at a very, very huge disadvantage. So there will be no procedural justice. The process by which a decision will be made by the court would not be fair. So justice requires access to the law. Right? Access to the law. access to the law. So this is arguably achieved as no one in the UK and in many countries is specifically denied access to the law. So no one is denied access to go to court to report an issue. And when you look at it, it looks like, oh, it's fair. We've made it. Everyone can gain access to the law, to the courts, and everyone can be helped, can have their case heard. It looks like that's all and is all has been said and done, right? It looks like everything is good. But no, effective access to the law is a different matter. Why do I say effective access? Because there are those who are less able to act for themselves, to represent themselves in court, or to pay someone to act for them. So if, like I said, there is no legal aid, then they have access to the law in a sense, but they really don't have effective access to the law because they don't have representation. Even if they can walk into a court and they can say, this person did this to me, but because they don't have access to someone to represent them, that other lawyer whom they will be against will completely decimate them, will completely destroy them because they don't know the law. And this is an expert. They've been to school for it. So effective access to the law is what we want. I hope you're picking up what I'm putting down. So let's look at the second type of justice. It's called corrective justice. Corrective justice. So we're looking at sanctions, we're looking at damages. So sanctions, for example, means if someone breaks the law, how are they going to be punished? Those are the sanctions, the punishments that they get. Damages, if someone is negligent, he hits my car, we have to pay damages. They have to pay for the car to be fixed. We call those damages. So we're looking at corrective justice, and we're also going to be dealing with sanctions and damages, right? So corrective justice is also known as restorative justice. This is when the law restores the imbalance that has occurred between two individuals or between an individual and the state. So corrective justice is about, we want you to be back to the position you were before what happened, before someone broke the law, before someone damaged your property. So how do we do that? If someone damages your property, we say they should pay you for the damage that they caused. So we are trying to restore you to the position you were before the damage occurred, in as much as money is able to do that. Okay, so let's look up at something. When judges or magistrates pass a sentence on an offender, they take into consideration a number of factors. So this includes the aim of the sentence. What are we trying to achieve by giving this sentence to this person? No, number one, this may simply be to punish the offender for breaking the rules. So the aim of the sentence might just simply to be, we want to punish the offender for breaking the rules. Number two, it can be to deter others from committing the same offense, to use them as an example that if anyone does this, this is what happens to them. However, balanced against these aims may also be the desire to rehabilitate the offender. So rehabilitation, we're talking about, we want to put this person in prison so that they may learn their lesson and come out better people. The court will also consider what are called aggravating and mitigating factors relating to the offense, relating to the offender, right? So aggravating factors are, for example, someone left their house and they took an axe and they said, I'm going to beat that person. He can't spread gossip about me. And people told them, don't do this, but they continue. They went, they sharpened the axe. They knew this axe could kill a person, but they still proceeded to hit that person. These are aggravating factors. These are things that shows or that demonstrates to the court that this person should be indeed punished very well. So these are aggravating factors, but they're also what are called mitigating factors. For example, if someone were to steal some medicine from a pharmacy, right? There are mitigating factors. It could be, for example, that person has a sick mother or a sick sibling or parent, right? And they are at the verge of, they're about to die, right? And this person has no money, he has tried to borrow money, no one is helping him out, and then he finally decides, I'm going to just go and steal. The reason, yes, they have committed a crime, yes, they must be punished, but there are mitigating factors. This was not because this person is just a thief. It was just because he was just trying to save his or her parents. So these are called mitigating factors. The court will look at it and say, this is not really a bad person. He was just trying to save someone's life. So we look at the mitigating factors relating to the offense. Sometimes some offenses could be unintentional. It's an offense, or the offender could be in a state of panic, and then they do something. The court can look at it and be like, yes, man, this guy only did this because he was panicking. It was not really something that he was thinking about and planning on doing. So these things can cause the court to reduce the sentence, or if they are aggravating factors, to increase the sentence, right? And the courts will also have to follow what are called sentencing guidelines. So in every legal system, or in most legal systems, there are what are called sentencing guidelines. These are documents that helps the magistrates and the judges to give proper sentences. So they will say, if this person did this, you should look at sentencing them for maybe this amount of years. There are guidelines. They help them to make their decision on maybe how many years they're supposed to be in prison, or any punishment that they decide to give to the offender who is found guilty. Now let's look at civil law, right? Corrective justice. Let's look at civil law. So in negligence, right, the aim of compensating is to restore the claimant to their pre-tort position insofar as money can achieve this. So remember, we talked about civil law. If you don't know it, again, go and look at the video. And we talked about a tort. A tort is a wrongful action that causes harm to someone or damage to some property, right? And so the other person who causes the damage should pay for the damage that they've caused, right? So it could be damage to a car. It could be damage to someone's reputation. You could publish something false about a person. It damages their reputation, and maybe they lose business because of that. You have to pay for the damages that you have caused by publishing such an article or such a tweet or a video on Facebook. You have to pay because you have damaged their reputation, and as a result, they've lost money, they've lost connections, they've lost business. So in negligence, the aim of the compensation, remember I was saying, is corrective justice, right? Is to put that claimant back to the pre-tort position where they would have been had the tort not occurred. So to balance this, any contributory negligence on the part of the claimant will reduce their reward. So when we're looking at contributory negligence, we're looking at, for example, if an accident occurs, right, and maybe I'm the one who went and smashed into your car with my car, right, and clearly I am to blame for the most part, right? But if your car is supposed to be fixed for $1,000 and I did something wrong that caused your car to be damaged, that caused me to smash your car, but you also did something wrong, you contributed to the accident, the court will say the car is supposed to be fixed for $1,000. I have to only pay maybe $600. The $400 is going to be on you because you also caused your own accident. You also caused your own damage. You are also negligent in your own way. So if you contribute to the damage to your car, then you also are supposed to pay part of the damages to fix your own car, because we both contributed to the accident. I hope this is crystal clear. So for example, in the case of Christopher Jebson versus Ministry of Defense, we see this issue of contributory negligence. Christopher Jebson was suing the Ministry of Defense for negligence after suffering severe injuries that ended his military career. And here is what happened. Jebson, who was a soldier, was on a recreational trip with his unit, which was organized by their commander, to a local town for a night out. The Ministry of Defense provided a lorry with a driver for transportation. During the return journey, most of the soldiers, including Jebson, were drunk, and there was no officer supervising them. So Jebson attempted to climb over the truck's canvas sides at the encouragement of his colleagues, and he fell, and he suffered serious injuries. So he took the Ministry of Defense to the court, and the court ruled in the favor of Jebson, stating that the Ministry of Defense owed a duty of care to Jebson. They shouldn't have left the soldiers at the back of the truck alone, drunk, without anyone supervising them, because they had gone out, they had drunk. They should have had someone at the back of the trunk supervising them, but they did not have someone. So although the court found Jebson's actions to be reckless, it determined that the injury was foreseeable. It is something that the commander could foresee. It is something that was possible, that he could have taken steps to avoid, given the circumstances. As you know, the soldiers were drunk, and they were, the rowdy behavior behind of the drivers in the lorry. The commander and the drivers and everyone, they could tell that something like this could happen, but they did not do anything to prevent it from happening. So in that sense, they were guilty of not honoring their duty of care to their soldiers. However, the court also decided that in as much as the Ministry of Defense and the commanders did not honor their duty of care, did not do the right thing in putting measures in place such that when the soldiers were coming back and they're drunk and they're having rowdy behavior at the back of the truck, that there will be someone to monitor them. Even though they did not do that, the court also decided that Jebson also contributed to his own suffering and injuries and accident. He contributed. He was not pushed. He tried to do this thing on his own. So due to Jebson's contributory negligence, his damages were reduced by 75%. So for example, if he had claimed 10,000 US dollars or 10,000 pounds sterling, the court said, no, we're only going to give you 2,500, because the other 7,500, you are the one who caused it. You contributed to your own damages, so we're not going to award you that amount of money. So you're only going to get 75%. So the Ministry of Defense will only pay the 25% of the damages that you're demanding or that you're claiming from the Ministry of Defense. So this is one such case where we see that the balance, the court will also try to balance any contributory negligence on the part of the claimant. Now let's look at contract law under corrective justice. So the basis of assessment of damages is of bargain. And what does that mean? A bargain is an agreement of exchange between two parties. So if I'm coming to you and I'm selling you these headphones, right? And I say, this is for $10. And then you say, no, I have 8. And then I say, no, make it 9. And then we agree for $9, right? We have made a bargain. We've made an agreement, right? So we have made an agreement. So the basis of assessment of damages when it comes to contract law is that of bargain. It means that when the courts are assessing the amount of damages, they will look at the agreement that you had. So this is going to make sense in a minute. So the claimant is placed in a position they would have been had the contract been performed. So for example, let's say we enter into a contract. I sell fruit juice, right? And then we enter into a contract where you sell blenders. I order a blender from you. I pay you for the blender, right? And then you tell me that Monday morning by 8 o'clock, you would have brought my blender. And you know that this blender is what I use to make my juice. And I sell my juice every day. And then Monday morning, I've already paid you, but you don't bring the blender. Tuesday morning, you don't bring the blender. I call you, you keep telling me statements. Wednesday, you don't bring the blender. Then I can take you to court and say, we had an agreement with this person. I've lost $30 over the past 3 days because I could not work. I have paid him for the blender. He had my money and he didn't bring my blender. And on Monday, I was supposed to make $10 with the blender. I did not make it. On Tuesday, I was supposed to make another 10. I did not make it. On Wednesday, I was supposed to make another 10. I did not make it. So I'm going to claim $30, all the money that I lost because I did not make juices. I did not sell juices because you didn't bring my blender. I can take you to court, and the court can award me those damages and say, yes, you're supposed to bring the blender. That was the agreement that you made with this person, and you didn't bring the blender. So pay them $30 because they were supposed to be $30 richer right now. They're supposed to have $30. Had you brought the blender, they would have made the juice. And this is what they do on a daily basis. So we are trying to put the claimant, me, the one who sells juices, in a position I would have been had the other party, had you brought my blender on time. However, only losses that are reasonably within the contemplation of the parties may be recovered. I'm going to illustrate this with the case of Victoria Laundry versus Newman Industries. So this is going to help us to see what I mean by this. So this case is a landmark case means like a big case regarding damages for breach of contract, right? Specifically focusing on the remoteness of damage. So it's going to make sense in a minute, everything that I'm saying. So here's what happened. Victoria Laundry, a laundry business, they wanted to expand. So they ordered a new boiler from Newman Industries. And Newman Industries knew that Victoria Laundry needed the boiler for their business operations, but did not know about any specific lucrative dyeing contracts they had. So the boiler delivery was delayed, and Victoria Laundry sued for lost profits due to the delay, right? So like I said in the other example that I gave you, that if, like in this case, Victoria Laundry, it uses the boiler for its day-to-day business, right? And it orders the boiler from Newman Industries. Newman Industries did not deliver the boiler on time. So the amount of money that Victoria Laundry was supposed to make in their ordinary course of business, what they would have made had in the normal day-to-day running of their business, had the boiler machine be brought on time, that amount of money, Victoria Laundry can go to court and say, we were supposed to have made this amount of money, but Newman Industries did not bring our boiler on time, so we are claiming that amount of money, and the case can be won, and Victoria Laundry can be awarded that money, and Newman Industries would have to pay that amount to Victoria Industries. But let's look at what happened to the court. So in this case, the court had to decide whether Victoria Laundry could recover damages for, number one, the normal lost profits from their general business expansion, which means this is the normal amount of money that they were supposed to make had the boiler machine been delivered on time. Number two, whether Victoria Laundry could recover damages for extraordinary lost profits from specific lucrative dyeing contracts. The court decided that Victoria Laundry could recover damages, or Newman Industry would pay damages to Victoria Laundry, for the amount of money that they were supposed to make. That was in the normal course of business, just the general amount of money that they were supposed to make. But Victoria Laundry was also saying that we had an amazing contract that was supposed to give us loads of money that are not the normal amounts of money that we used to that we would make in the normal course of business. We are also demanding that Newman Industry give us that money that we lost. And the court said that Newman Industry will not be paying for those damages, because Newman Industry would not have reasonably it was not reasonably foreseeable that the court was that Victoria Laundry was going to lose money from a lucrative deal. In fact, Newman Industries did not know about the lucrative deal. So how would they possibly have known that they are making Victoria Laundry lose money? So the court decided they could recover money from the amount of money that they were supposed to make in the normal course of business, but not money that they were supposed to make from the lucrative deal that they were supposed to have entered. So that's that from the lens of contract law. So let's look at criminal law, right? And we're still under corrective justice, right? You know, there's a trial by jury where we have a jury or a pool of people who will then decide the verdict of the case after hearing the case, right? So a trial by jury enables jury members to use their view of justice, right? It's different from where the one judge who's sitting on a bench and he's the one who decides whether a person is guilty. But a jury will allow people to use their humanness to decide whether a person is guilty or not. And also they don't have to adhere to strict rules of law and all of those things. These are just normal people who are asked to judge whether a person is guilty or not guilty. So the rules of evidence adopted in criminal trials seek to balance the interest of the parties to the action. I will look at some of the rules of evidence in the later example. So for this reason, evidence of previous convictions is not generally admissible unless the facts are strikingly similar to those in the instant case, right? So what that means is you cannot go, right, and say, this person in a court, right, maybe someone is being accused of murder, right? You cannot go and say, no, this person was actually convicted of rape last year. Because what that does is it makes the jury and the judge or the judge to be biased. So even if this person did not actually commit the murder or the crime at hand, but because they have been previously, because now the jury knows that this person was previously convicted maybe of rape or something like that, right? They will think that this person has committed the crime. They will start to see this person as a criminal, and they were most likely going to decide that this person is guilty, even though the evidence might not be supporting that. So evidence, the rules of evidence adopted in criminal case, they seek to balance the interest of the two. Yes, we want to put the person behind bars, but we also want to put the right person behind the bars. So the other person is also an interest to defend themselves and not to be in a case where the process is not fair, the judgment is not fair, because they are using his previous mistakes to judge him in this instant or in this case at hand. So the things about previous convictions, the evidence about previous convictions is admissible in very exceptional cases. For example, where the cases are strikingly similar. So for example, a person who is being convicted on charges of rape, right? If they have been previously convicted on child molestation and things like that, we can use that in certain circumstances as evidence to say, look, there is a pattern here. There is a pattern. This person has been convicted of raping, of molesting the individuals, and then afterwards pulling a gun on them and threatening them. If that is what they're being charged with now, we can use that evidence to establish a pattern, to say, this is actually their behavior, this is their modus operandi, or the mode of operation. So we are not going to include all the evidence, right? So that's what we have established, that not all evidence is going to be included. So we have said that not all evidence is included because we want to protect the interest of both parties, right? Someone who has done a crime before does not necessarily mean he's done it now, right? However, on the other hand, even illegally obtained evidence may be admissible, right? So for example, in the case of Jeffrey versus Black, the police arrested a student for the theft of a sandwich, right? And when they and then they went on to conduct an illegal search, right? Because the police cannot just barge into someone's house and say and just say, we want to search your house. They need to have a search warrant from the judge, from the court, right, that allows them to do that. So they did not have a search warrant, but then they just went in and barged and got into this student's apartment, and they conducted an illegal search. And whilst they're conducting this search in his flat, they discovered drugs, but the search was illegal. So can we allow this evidence that has been obtained by illegal means to be presented in the court? That was the question. Now, when the court was heard the first time, the magistrate threw out the case after ruling that the evidence was not admissible. It was inadmissible. You could not present it in court because it was illegally gotten, right? The judge, the magistrate was simply saying, we will not condone, we will not support the police in breaking the law, so we will not take this evidence, so we're not going to hear this case because the evidence on which it is based is illegally obtained. However, the divisional court ruled that the illegality of the search did not justify the excluding the evidence it had exposed. So the higher court, when the case was then taken to a higher court, the judge was like, no. Yes, the evidence was obtained illegally, but we're going to still allow this evidence because it exposed a crime. Now, you can say this is unjust, right? Because that means that the police can just get and start to do things outside the law and we'll just support them, right? But we also have to consider, for example, a situation where the police discover plans and materials to commit a terrorist attack, but they do it illegally. They have, after conducting maybe an illegal search, would you say, no, let's let the terrorists go? They were about to bomb a school and kill 1,000 kids, but let's just let them go because the evidence was obtained illegally. Would you do that? No, you wouldn't. So you can see the logic that sometimes, even though the evidence might have been obtained illegally, we can still allow it to be presented in the court. However, but allowing illegal things to happen might also lead to people who have not, who do not have, who did not commit the crime to even end up being put behind bars, because we are just now allowing anything to happen. And sometimes the police can even end up fabricating evidence, making up evidence, if we keep allowing such things, and we end up having people who are not guilty put behind bars. And so we don't want that. So that's one of the things that we need to be careful of. Guys, I'm excited that you got to the end of this video. This is only part 1 of law and justice. Please do me a favor, if this is adding any value, subscribe. If you want to join our online school, even an online school where I personally teach law with my team of lawyers, we can teach you A-level law and many other subjects. So if you want to be part of that, just check the details in the description of this channel or of this video, and we will get in contact with you. Can't wait to work with you guys. I love you so much. Until next time, peace.